Hello students, welcome back to an academy. In today's discussion, we are going to proceed with the day 9 of our 456 topics for the prelims 2026. Making sure that you are happy, we are starting with today's discussion. So the topic for today we are discussing is fundamental rights. Before starting, this area which is called as fundamental right have been repeatedly asked in the UPSC Civil Services Examination Prelims. But most of the students actually by heart it. They try to mug up it without the conceptual or the logical reason behind it. For example, there are some fundamental rights which are only exclusively given to the citizens of the country, whereas the other fundamental rights are accessible and applicable to everyone who is residing in the country. So rather than just by hearting 5 15 16 90 29 30 are for the only for citizens, rather than if you can actually understand what might be the logic behind it, polity becomes very interesting, as well as the preparation also become interesting. So what I can assure you that in this 2 sessions, most probably we'll go with 2 sessions, we will be covering all the fundamental rights from 12 to 35 articles with utmost conceptual and logical clarity. So with that discussion, let's start. So when we talk about the fundamental rights, this is an overall picture. Fundamental rights, now you can see we have classified it to under 6 fundamental rights ranging from article 12 to 35, but initially it was 7, and one fundamental right we have removed it. During the course of time we will discuss it. So now we have 6 fundamental rights, starting from right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational right, right to constitutional remedies. Now, first, from where exactly this idea we have inspired from? The idea of constitution is inspired from US basically. So in US there is something called a Bill of Rights. So this Bill of Rights means in US there were 10 amendments added to the US Constitution to protect the citizens' freedom. These amendments are what are known as the Bill of Rights in the context of the US. Now our part 3 of the Constitution, that is fundamental rights, got inspiration from the US from their Bill of Rights. Now it is also called as the Magna Carta of India. Now Magna Carta, the word is a Latin word which means a great charter. So way back in 1215, King John of England, he is the one who came up with this Magna Carta, in which it was mentioned that king is not above the law. It gives a restriction on the authority of king. First thing, to abide by the law, he is not above the law, as well as against the arbitrary powers. So these two things, one we have inspired from USA, and the other thing is that we often call this part 3 as the Magna Carta. Now, unlike the preamble we discussed, or like the fundamental duties, or like the DPSP, one of the most important thing with reference to fundamental rights are it is actually justiciable, which means that you can approach any court if these rights are violated. And what kind of ideal we are trying to promote? It is of the political democracy. And what does this rule of law means? Rule of law means the primary aim to establishment some government or laws. It should be government of laws and not of men, which means the government regardless of which position that people are holding in the government, everyone should go with the law. No one is above the law, and there is nothing called like a man, he is minister or he is prime minister. So this is what we call it as rule of law. So remember from where we inspired this, from the US Bill of Rights. Why we call it as Magna Carta? These are justiciable rights. This promote the ideals of political democracy. Now having said this, now why fundamental rights are called as fundamental? That's the first thing that we have to address, for two reasons. First thing, it is enhancing the constitutional protection. Basically this gives us the citizens as well as the residents also, because I told you fundamental rights, few fundamental rights give protection for the residents also, even if he is a foreigner but still residing in our country. So this is something, the guarantee that constitution is giving us, and it also ensures a holistic development, because these are considered essential for our material development, intellectual development, moral development, and spiritual development. All these are necessary for a human, for a man to survive and sustain in this world order, right? So he should have that intellectual freedom or that intellectual development, moral development, as well as spiritual development. Spiritual may be related to God or atheism, that is not the matter, but this all-round development as well as the constitutional protection is what actually fundamental rights are trying to put in front of us. Got it? Now we have already told that how we have actually classified it. We are classified into right to equality, right to freedom, right against exploitation, right to freedom of religion, and cultural and educational right. Now when talking about the inception of it, we had 7 fundamental rights. From the beginning, originally we had 7 fundamental rights. And also you have to understand, the latest amendment that was added to the fundamental right, except everything, the 2 changes I am talking about. Initially we had 7, and one fundamental right was taken away. That was right to property under Article 31. This Article 31 was taken away, and that amendment is what is known as the 44th Amendment, which is important to study. 44th Amendment. 44th Amendment. So since the inception, that is of 1950, we had 7, and one fundamental right, that was right to property, was removed, which came under Article 31. It was deleted, and now that is a legal right. It's not completely deleted from the right perspective. It's still a right, but it's not a fundamental right. It's a legal right, which means if it is being taken away, you can go to the court still. Don't confuse, you cannot go to court. You can go to court, but under the ordinary laws. You can't go with a writ to the courts. So right to equality, right to freedom, right against exploitation, freedom of religion, cultural and educational right, as well as the last one is the right to constitutional remedies. It's not just giving you some right and leaving it. The 30 seconds says about like how you can actually get done of this. If any arbitrary power is being used upon you, how can you actually be protected from it? Now, as I said, and one more thing, the 2 changes which happened to the fundamental rights, one is the removal of the right to property, and the other change that was brought in the 86th Constitutional Amendment Act, which inserted an article under 21, which is 21A, and I hope you know what is this article 21A means, which talks about the right to education, right? So the 2 changes, major changes, one is deletion of the right to property, now it is a legal right. Then the major change happened was of insertion of the 21A under the 86th Amendment. Now when talking about the fundamental rights features, there are some which are only available to citizens, while others are available to other residents who are residing in our country also. Understood? Now, all the fundamental rights, these fundamental rights are not exclusive on you, they are qualified. Qualified का मतलब क्या है? States can actually, whenever there is a requirement, it can actually impose some reasonable restrictions on them. Again, reasonable restriction, and there should be some justifiable situations in the state. Okay, now we have said that there are some fundamental rights which are only available to citizens, but there are some other fundamental rights which are available to all the people who are residing in our country. Just to understand, now what are these fundamental rights? So listen here first. The fundamental rights which are only available to citizens, I will tell, which are, you can just study now itself, 15, 16, 19, 29, 30. You have to by heart 15, 16, 19, 29 and 30. Now listen here. What is Article 15 talking about? Prohibition of discrimination. What about Article 16? Public employment. What about Article 19? The 6 freedoms that are being given to you. What is Article 29? Protection of the culture. And what about Article 30? That is minority education right. Now, if you closely observe this right, it is very citizen centric. That is the exclusive freedom that you are enjoying being a part of this democratic sovereign republic country. For example, the public employment, this is not something a natural or human right? Because that is for the Indian people. Public employment, prohibition of discrimination. Discrimination not just mean about caste. So discrimination, for example, if I want to make citizenship as a qualification for something, yeah, I have to make it. Then no foreigners can come and say that you are discriminating me. Assembling, peaceful protest, culture. How can the constitution expect some foreigners come and they do the promotion of their culture, which will be contradicting? Minority educational right. If any minority community from some other country, some foreigners, a group of foreigners come to India and they say that we have to promote it, will it be possible? So 15, 16, 19, 29, 30, if you see the behavior of these fundamental rights, those are exclusively for the citizens. Those are very citizen centric. But on the other hand, if you see the common fundamental rights, for example, Article 14, equality, Article 20, protection in criminal cases, Article 21, right to life, and Article 21A, education, Article 22, protection against arrest, Article 23, prohibition of trafficking, Article 24, prohibition of child labor, Article 25, freedom of religion. Now you observe here, all these things, equality, protection in criminal case, right to life, education, against arrest, against trafficking, against child labor, again for the protection of freedom of religion. See, whatever we said here, these we can classify as basic human rights. This is the logic you have to understand. So which are only exclusively available to the citizens, that doesn't look like an basic human rights. But whichever is even available to the foreigners, those rights, it will look like, it will sound like the basic human rights that you have to get as a human. Education, life, no doubt, rights. And there should not be a kind of a arbitrary arrest on you, whether you are an Indian or a foreigner. When you are in this land, you are also protected in that. So this is the difference. Okay, and some fundamental rights are against the state to prevent the arbitrary action of the state, but some are against the individuals also. For example, regarding untouchability, even if you are also promoting it as an individual, yes, you are also taken under this particular ambit. I hope it is clear, right? Now, the key features I already told you. Negative fundamental rights are there which limits the state authority, and positive fundamental rights are there which are limiting the persons as such. Then Supreme Court has also a kind of a protection. They are defended and guaranteed by the Supreme Court through writs. Who will take care of this? It is the Supreme Court as well as High Court also, but that is not in the Article 32. Be very careful. Now, what about the amendability of the Constitution? This is something very important. Amendability of Constitution is also important. Whether the Constitution, whether the fundamental right can be amended. Actually, four major judgments were there based on this. So, amendability as the latest status, it is amendable. But court also observed that this is not something like sacrosanct or permanent. Parliament have the right to do it. Now I will tell you about four important cases in this regard. In 1951, there was a case called Shankari Prasad case. In Shankari Prasad case, what happened? Shankari Prasad case, the court observed that fundamental rights are amendable. But later in the 1967 Golaknath case, Supreme Court said fundamental rights are not amendable. Then in 1973, as you know, Keshavananda Bharati case, which is very famous for the basic structure doctrine. In that case, Supreme Court again said, no, unlike the Golaknath case, where it said fundamental rights are not amendable, here it was said that yes, fundamental rights are amendable, but the basic structure of the Constitution should not be demolished. You can amend, but if it is touching on the basic structure, there comes a stop on you. And later in 1980 Minerva Mills case, here they said yes, limited amending power is what said in the Minerva Mills case, which means that you cannot destroy the fundamental rights in name of DPSP. So what in that point of time, what happens is governments were trying to implement the DPSP by curtailing the fundamental rights. So this was actually, put into some kind of questioning in the Minerva Mills case. So these are the four cases upon which the amendability of the fundamental rights were discussed. So latest is that you can amend. As per the latest thing, you can amend, but it should not impact the basic structure of the Constitution. Now, these fundamental rights, we have told that it is not absolute, right? Now, the best situation is that if in any case any national emergency is there, these fundamental rights except 20 and 21. So 20 and 21, what is the importance of 20 and 21? 21 is right to life, right? And 20 means protection in criminal cases. So except Article 20 and 21, all the fundamental rights can be taken when there is a national emergency. Got it? Yes. Now we'll start with the Article 12. So 12, basically, before you are going to the we have told that many fundamental rights are against the state. Now first, Constitution is defining what is meant by state as such, because you can't say because state doesn't mean that only the public body or the government you are seeing. So Article 12 defines that we must define the state as government and the Parliament of India, which means executive and legislative organs of the Union. State governments and legislatures, which means executive and legislative organs of the state. Local authority like municipality, panchayat, district board, etc. Then statutory or non-statutory authorities like LIC, ONGC, SAIL, and then comes the most important thing. Even private entities can also be considered as a state when coming to the fundamental right. For example, national highway construction is taken by a private contract company. Since they are performing a public duty, then when any private body do some public function or performing some public duty, then that private body can also be called as a state. This is very important. So state just doesn't mean that only the state that we are thinking, basically the parliament, executive, legislative, municipality, panchayat, but even private entities also comes under the ambit of defining the state. Okay. Then one important question here which you may get confused. We have said that almost everything, judiciary, executive. Now the question is judiciary itself. So this judiciary will come under the ambit of state. So this is not mentioned in the constitution. So be very careful if that term is given. Okay. However, the judiciary is bound by the constitution and cannot create root violating affairs, which means that if they are giving a direction, Supreme Court cannot encroach in violating the fundamental rights. But you know, when define the state in Article 12, it is not given. Supreme Court is not given as a state. The famous case was in Ruba Ashok Hurra versus Ashok Hurra. The Supreme Court clarified that superior courts, either SC or HI court, do not fall under the scope of Article 12, that is under the state definition, but their proceedings or whatever they are doing cannot violate the fundamental rights. So this is important, you have to understand. Now judicial review, Article 13 talks about it. Okay, so which means that in any case Parliament goes for adapting a policy or adapting a rule or anything it may be. So law, it called as a law, which means any law that Parliament or assemblies are passing which is against the idea or against the fundamental rights shall be void. It is void. It will be nullified. So now what all comes under the law? This is also important. Any law passed by the Parliament, even temporary laws, listen here, ordinances can also come under this ambit of law. So any ordinance governor or president comes up, it should not also inconsistent with the fundamental rights. Then delegated legislation, executive orders, bylaws, rules, regulations, notifications, even customs are also mentioned. For example, any kind of custom which is actually against the fundamental right, it is also coming under the judicial review, which means that the Supreme Court can come and make it invalid, which will be void. That's what Article 13 says, power of judicial review. But what about constitutional amendment? Will it come under law according to Article 13? I'm talking the technicality of it. No, it is not mentioned under Article 13 as a law, which will be coming under the judicial review. But as per the tradition, it cannot be in the as per the Keshavananda Bharati case. Yes, fundamental rights cannot be amended if the basic structure is going to be impacted. Now comes the right to equality that starts from Article 14 to 18. So Article 14 talks about equality before law and equal protection of the law, right? So what is equality before law and equal protection of the law? So it says that the state shall not deny any person equality before the law or equal protection of the law within India. But there are some exceptions. President and governor, they have exception. MPs for statements made in the parliament, be very careful. In his personal life, outside the parliament, things are different. But inside the parliament, if he make a statement, he is not coming under this. Okay. Then any diplomatic immunity for any foreign ambassadors, for these people, they also have immune from any civil and criminal proceedings. That is different. Any ambassador of Japan, ambassador in India, he will have this immunity. So we can't go and ask that we have equality before law and equal protection, then why he is not being put into this proceedings and all. We can't question that. We can't question based on president or governor or for the MPs for the statement they made in the parliament. Also, any law giving effect to Article 39B and C can override Article 14. So what is 39B and C are DPSPs. 39B says about resources of a country should be distributed fairly. 39C says concentration of wealth should not be at few hands. These are 39B and 39C. If state want to do something against it, it can override Article 14. Understood? So this is what. Now Article 15. Here also be very careful. Wherever I have highlighted in the red color, there is a area where there can be trap can be set. So discrimination is not possible. But listen here. On what grounds discrimination is not permitted? Religion, race, caste, sex, or place of birth. Or place of birth. There is no residence in it. Which means that For example, in some cases, for example, in a government job or something, in case of residence, I can do some discrimination, because you are coming from some other state or coming from some other country. Just being a resident, I can't you can't say that you should not discriminate me. If you are born in India, if your place of birth is here, then discrimination can't be done. But you have to also understand, discriminations are possible when regard to age, with reference to education, with reference to your economic condition, which means that if you are economically weak, there can be some things can be done for you. Understood? Then residence. But here it is only place of birth when we talk about the Article 15. Okay. Now there are some permissible special provisions for women and children, for SC, ST, OBC, EWS. We give them some special consideration. That is another thing. Now Article 16 talks about equality in public employment, which means that again, no person should be discriminated or kept out of the public employment because of his religion, race, caste, sex, descent, place of birth or residence. Now, who can actually make laws on this? It is only Parliament, not the state legislature. Be very careful about it. Okay? But in case of religious office, for example, Devasam board or Waqf board. Waqf board, now it is not like that. Now non-Muslims are also there. But the best example is that of Devasam boards. Yes, government can bring some criteria that only Hindus can be allotted here. That is an exemptions. So exemptions also you have to study. Understood? Not just studying that equality of opportunity for all citizens. This everyone will study. From here only questions will be asked by the examiner. Okay. Then after that comes abolition of untouchability. Now question here is, this word untouchability is defined in the constitution or not? It is not defined in the constitution. Be very careful. Then how we are actually understanding this concept? This concept we are understanding because of the historical practices that have been transformed from generation to generation, and also to give practical implication to the abolition of untouchability. The government have come with the act which is known as the Protection of Civil Rights Act. This is the act which enforces this particular law. And then Article 18, abolition of titles. When talking about titles, it only abolishes the hereditary titles. For example, you cannot take any titles like, Maharaja, Nawab, Maharaja, Raja, Nawab, all these things. It's not, because it will create a distinction among the society. So these hereditary titles are prohibited, but exceptions are there. Any title except military or academic distinctions cannot be given by state, and citizens cannot accept titles from foreign state. And if any ambassador who is posted in some foreign country, Indian ambassador, if he wants to get some title, he wants to consult the Indian president. But Bharat Ratna and Padma awards are not titles and do not violate Article 18. Which means you cannot say that I am Padma Sri or Bharat Ratna Mohamed Azhar. But when you write, or when a person is explaining about him, when we are making some announcement and all this, but I myself can't come and say that I am Bharat Ratna. Okay, but understand, these two things are not coming under the, and it does not violate the Article 18. Now right to freedom from Article 19 to 22. Okay, so there are basically 6 rights which have been given: speech and expression, assembly, association, movement, residence, profession. Now what I have highlighted in the red color, the right to acquire or dispose of property, was deleted by the 44th Amendment, which was also part of this. Okay, now these freedom are also subjected to the sovereignty, integrity, public order and morality. If at any cost this is being impacted, that can also be taken. Then Article 20 is protection against conviction, which means that when a person is accused, he has got 3 protection. One is ex post facto law, which means You cannot be punished for an act that was not a crime when you committed, because you committed a crime. For example, bringing iPhone from Gulf, that is, I brought in 2020, but now that has been made as a crime. Now you can't arrest me. That is what ex post facto law. You cannot be punished for an act that was not a crime when you committed. When you committed, that was not a crime. Bringing iPhone from Gulf was okay, but now that is something. But this applies only to criminal laws. Listen, it is not applicable to civil or tax laws. For example, you were skipping the taxes for last 10 years. You can't say that ex post facto law is applicable to me. No, it is only applicable to criminal law. If any activity you did previous, now it has become a criminal activity, you can't be arrested. But in terms of civil or taxes, you can be arrested. No double jeopardy, which means that for the same offense, you cannot be punished twice. And no self-incrimination. You should not be compelled to witness against yourself. But exception is there. If the state asks you to give your thumb impression, blood sample or signature, you have to give. That doesn't come under the protection against conviction. Then protection of life and liberty. So protection of life and liberty comes under Article 21, and in this only right to education comes as Article 21A. Okay, so no person shall be deprived of life or personal liberty except according to procedure established by law. Okay, so this is what I said. Article 21A, right to education was brought from between the age 6 to 14. Okay, and it's not 6 to 18. Many times you get confused, and this was added in the 86th amendment through Right to Education Act of 2009. So this is what we have planned for today. We will continue with the fundamental rights for tomorrow also. One more session we will take, and I hope rather than the rote learning, you have understood what is the logic of each and every fundamental right and the subjectivity of it and the exclusions that we have did, as well as the awarding of the fundamental rights to specifically to citizens as well as for everyone who is residing in the country. I hope it is understood, and happy learning. This is me signing out from today's session. Thank you, and let's crack it.